The next case to come before the court is State of Ohio v. Thomas Clark. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I will be keeping track of time. The arguments are being recorded. I don't know if you intend to come up to the podium, but if you do, please remain there and keep your voices up. We have read your briefs. I should remind everybody that you should not use the names of children or minors or victims during your argument. You can refer to them by initials or general terms. And as I mentioned, we have all read your briefs and we're ready to proceed when you are, but I would ask the appellant to please let me know if you would like to reserve time and how much, because I'll be keeping track of the time. Would you like to reserve time for rebuttal?
Yes, Your Honor.
And how much?
5 minutes.
Very well, then you may proceed when you are ready.
May it please the court. I am Lydia Spraggin and I represent Mr. Thomas Clark on this matter. Can you hear me?
Yes, we can, thank
Great.
you. And if you should need to sit, that's okay too.
We thank this court for the opportunity to present a de novo appeal. Since the state says that this appeal is meritorious, but this is an opportunity for this court to speak clearly, definitively, and instructively. We are asking that this court utilize all of the records of the trial court, review the laws and the evidence without considering the ruling made by the lower court. We believe that once this court conducts such a review of the issues that may have been incorrectly decided or not sufficiently addressed in the lower court's decision and docket entries, the court will find in favor of Mr. Clark. I want to take a look at the state's brief, if I could, for a few minutes. On page 3 of the state's brief, the state seems to believe that Clark 1 was decided in such that the court would simply vacate the sentence. If you look at Clark 1, and it says, in paragraph 1, the court reverses. Then, where it says assignment of error 2, the plain language says, the record is devoid of any voluntary, knowing, and intelligent waiver of right to counsel by appellant, and it was not done in writing, and his conviction must therefore be vacated. Conviction. It is axiomatic that a guilty plea is a conviction. And this court, on page 7, says, Clark's second assignment of error is sustained. Now, if we take a close look at the second assignment of error again, there is nothing in there about the sentence. It talks about the conviction, and it is sustained, and it is asked to be vacated. Now, I have no clue, I wasn't there, but why the court did not follow the plain language of this court, I have no clue or idea. But they did not. They proceeded to debate what the court meant. Why this court did not simply just ask this court what it meant, I have no idea. But they did not. Mr. Clark then proceeds to argue that this court has vacated his guilty plea, and it is null, it is void. He continues and continues and continues through his counsel, without his counsel, on several occasions to talk about the void guilty plea. The court ignores it all, gets down to the actual sentencing, and says all motions not so ruled on basically are denied. At no point in time did the court actually take a look, apparently, at what this court said. So then we get to the point where we look at whether or not there was a delay. Now, there was a delay. There's no argument that this man was in the actual jail for 1,000 and some odd days. Okay? He files a habeas, basically throwing his hands up in the air and saying, "Hey, I'm in the jail! Come and see about me!" And the court does basically nothing. The court says, because you filed a habeas, we have to wait and see what the habeas says. But that's not what habeas law is for. It's a collateral attack on jurisdiction. And at this point in time, Mr. Clark is making every attack he can, either pro se or with counsel. So, we go forward. The habeas, the court docket says nothing. It's silent. Now, as a first-year law student, they tell you that the docket doesn't say so, it did not occur. I don't care how much you say it occurred, it did not occur. This docket is silent, says nothing. Mr. Clark's attorney gets up at some point along the way, and he says, I believe there should be a stay. Why? He didn't consult with Mr. Clark about a stay, and this is Mr. Clark's first time in the system, but he realizes that something here is not quite right. And Mr. Clark's attorney goes on to say there's a stay. However, the court does not document this stay in its docket. So there is nothing going on, and nothing going on. And finally, the stay is dismissed, and the court says, well, I guess we can get busy now. And so they do. And at that point, again, Mr. Clark says, listen, you need to dismiss. I've been here too long. And of course the state says the rules of superintendents are really just guidelines. Well, I'd like to think that the guidelines are the minimum. But the case law says that anywhere from 87 days to 13 months, and the closer it approaches a year, is presumptively prejudicial delay. In this case, we have 1,400 and some odd days. That's definitely over a year, approaching 2. There is a delay. Next, I'd like to look at here what is the consequence of this delay. The court has said that the consequence of this delay is divestiture of jurisdiction. And jurisdiction can be raised at any time. And all the way through, Mr. Clark is jumping up and down, basically saying, y'all have lost jurisdiction. But he can't really use those words because he's not really a lawyer, and this is his first time in court. And so he's using what he knows. You didn't tell me. You left me in jail for 5 months. You didn't act on any of my motions. You didn't give me my full right to counsel. And he keeps coming. And I think this court recognizes that something has gone awry. Something seriously has gone awry. Now, I think I mentioned in the close of my brief, this is a heinous allegation. But I have been taught that I don't have to like my client. It's not my job to decide and judge whether or not he has done right or wrong. That's up to the jury. My job is simply to ensure that his constitutional rights are protected through the process. That's all I'm trying to do. And that's all I ask you to do, is to look at the facts, look at the record, look at, without saying, and come up in your own mind. What happened here? What really happened here? This guy has been in the jail 1,000 and some days. And then somehow or another we get another pro-tunc order. After they have agreed that he's been in jail for 1,000 and some odd days, the non-pro-tunc order says, we're only going to credit you for 280 something. Why would you do that? I have been sitting in the jail all this time, and I'm not supposed to get any credit for it. I came in here on a rape charge. I got sentenced on a rape charge, and nothing changed in between time. Nothing. Why don't I get credit?
Attorney Sprague, I just want to let you know that you've moved into your rebuttal time.
I'm sorry.
That's okay. That's all right, you
Sit
can
down and be
continue or,
quiet.
okay. Very well, then you'll have 4 minutes and 50 seconds when your rebuttal time begins.
Yes, ma'am.
Thank you. Thank you.
Good morning, Your Honors. I'm Vince Vellucci with the Medina County Prosecutor's Office for the appellee in the state of Ohio. As I did in my brief, I'll address the first through the seventh assignments of error together because they all essentially make arguments having to do with the effect of this court's 2018 remand from Clark's first appeal, and also taking issue with what he believes was unreasonable delay after the remand. In Clark's second appeal, this court already rejected all of Clark's speedy trial and criminal rule 32A unreasonable delay claims. It's always been clear that this court's remand did not vacate Clark's guilty plea. The remand, the problem this court had that led to that remand was a lack of a written waiver of counsel for a hearing on a motion to withdraw Clark's guilty plea. The plea itself had counsel, and there was no problem with the actual plea itself. There's never been even alleged that there was a problem with the plea itself, really. And as this court has already held in Clark's second appeal, in terms of that motion to withdraw, he actually waived the right to have that hearing after the remand on the motion to withdraw his guilty plea. He waived that after the remand through his counsel, which he says he didn't agree with, but there's no evidence whatsoever in the record that he didn't agree with that waiver. In fact, this court specifically held that before the reopening in the second appeal. And then in terms of the effect of the plea itself, this court also had some pretty convincing language saying, it didn't explicitly state it as such, but in Clark 2, this court said, by pleading guilty, Clark waived the right to waive speedy trial. So obviously, that implies very strongly this court believes the guilty plea was still intact after the remand. We know that speedy trial rights don't apply after a defendant has pled guilty. In terms of the post-remand delay, you have to kind of get into the dates and what happened when, which I get into in the brief. But after the reversal and remanding to the trial court, a status conference was held on October 25th, 2018. At that time, Clark orally moved to withdraw his guilty plea, and the trial court set the matter for a hearing on November 16th, 2018. But that hearing never took place because on November 9th, 2018, Clark's appellate counsel filed a motion to withdraw as counsel. The trial court granted that motion, and then 10 days later, on November 19th, 2018, appointed Clark new counsel. Then, on February 28th, 2019, is when Clark filed his habeas petition with this court. So at a March 21st, so so about a month after that, at a March 21st, 2019 status conference, Clark's new counsel agreed that the case would be stayed pending the outcome of the habeas. There's no evidence in the record or anywhere else that Clark did not agree with this. Several months later then, on December 2nd, 2019, this court dismissed Clark's habeas petition.
Counsel, we've said repeatedly, excuse me, we've said repeatedly that jurisdictional issues, we can raise sua sponte and cannot necessarily be waived, depending on what the exact issues are. But just because somebody concurs that the court doesn't have jurisdiction, it doesn't mean the court doesn't have jurisdiction, right?
Correct.
Right, so I'm not sure that because everybody agreeing, how that affects the jurisdictional argument.
Well, I don't think there really is a jurisdictional argument here, Your Honor. This is,
Well, you were talking about the habeas.
and the habeas ultimately was rejected on the merits. He takes issue with a stay that his counsel clearly agreed to, so, that tolls any considerations, certainly, I think, but.
So you're saying it told the time even if he was incorrect and there was no way you could determine the jurisdiction of this court by acquiescence? I'm sorry, I'm not making myself clear, am I? You're looking at me like I'm crazy. Counsel cannot agree that a court doesn't have jurisdiction and therefore take jurisdiction away from a court.
Correct.
Okay.
But that's not what happened here.
Okay, so explain to me then.
It was just simply a stay to see how this court ruled on the habeas. So which was, I think, reasonable because you had something that had been filed in a higher court, and you got something pending in the lower court. It was very reasonable for the trial court to do that, especially when you've got both sides agreeing to the stay. I think it ended up taking quite a bit longer than Mr. Clark anticipated for this court to rule, but, again, when it comes to unreasonable delay, he talks about specifically the 5 months between October 2018 and March 2019, that 5 months. The rules of superintendents, as has been stated, create no individual rights in a defendant. They're basically a general guide. So Rule 40A3 of superintendent says that all motions shall be ruled upon within 120 days from the date the motion was filed. Essentially, the remedy for violating this is not reversal, but it's basically to stop tolling speedy trial time after a reasonable time has expired. But that couldn't be an issue here because there were no speedy trial rights after the guilty plea. But I would say that his counsel's November 9th, 2018 motion to withdraw was akin to a speedy trial tolling event, and it lasted until at least November 19th, 10 days later, when the trial court granted that motion and appointed him new counsel. Then the habeas was filed February 28th, 2019. That was 126 days after the October 25th, 2018 status conference, where he reasserted his motion to withdraw his guilty plea. Now, if the 10 days from November 9th through November 19th are subtracted until that motion to withdraw was ruled upon, now you're inside the 120 days, actually, to rule on a motion under the rules of superintendents. So they would actually consider that reasonable to dispose of a motion if we're taking that up to the habeas being filed. Clark talks about numerous oral motions, talked about in the transcripts, doesn't actually state what errors he's claiming. Clark has complained in the past that the court didn't explicitly rule on his October 25th, 2018 motion to withdraw his guilty plea, or essentially I think it was actually worded the motion to enforce the Court of Appeals decision and set the matter for trial. we know the court was correct to not grant that, because he didn't withdraw his guilty plea. But the court implicitly denied this motion when it didn't set the case for trial, first of all, and then when it didn't expressly rule on the motion and the case, he was sentenced and the case ended, it was deemed denied anyway at that point. State v. Gomez from this court talks about that. Clark states generally that his trial counsel failed to assert objections and file motions relating to speedy trial and sentencing. He doesn't say with any specificity what he believes his trial court should have asserted, but as I've already mentioned, any speedy trial claims would not have had any merit. He talks again about the merger question. The merger itself was raised in the first appeal, and then the ineffective assistance of counsel for not raising merger was raised in the second appeal, and this court specifically rejected that claim in the second appeal. And really, it had to be raised in the first appeal anyway. The ineffective assistance relating to merger is a separate claim from the actual merger itself claim. So that would have been waived anyway by res judicata. So again, most of these arguments that are being asserted now in the reopening were actually asserted in the second appeal and already rejected by this court. Possibly argued slightly differently, but the point of a reopening is to assert new arguments that first counsel was ineffective for not raising. And that's not what happened in this reopening brief. This is basically just reasserting all the same old arguments again that have already been rejected by this court, essentially. When it comes to the jail time credit, I will address that because counsel addressed it. There's no evidence in the record that the trial court erred it in any way with reducing the jail time credit. The cases tell us that it's perfectly acceptable to correct jail time credit errors with a non-pro-tunc entry, which is what happened here. Certainly there's not a lot of detail in the record as to why the court did that, but there's no record, there's nothing in the record that says that was incorrect for any reason, and Clark has to prove that, has the burden on that point. So if there were no further questions, I would simply ask this court to affirm the judgment of the trial court. Thank you.
Thank you, Attorney Peclucci. Attorney Spragan, you'll have 4 minutes and 50 seconds.
If you apply the sniff test to this, something smells in Denmark. And I think the court knows that something smells in Denmark because they reopened this matter. And that's why we are asking for a de novo appeal here. Because we do not believe that this court would find as the court below, especially in light of what the docket is devoid of, and the court speaks through its documents. I would like to address a couple of things that I raised in the reply brief. I too calculated it, and I'm not a mathematician, so I got the computer to calculate it for me. And if you look on page 5, I talk about 517 days from the start date to the end date, or 1 year, 4 months. 30 days excluding the end date, or 16 months, 30 days excluding the end date. Assuming a tolling for new counsel and discovery of 30 days, it is still outside of the reasonable scope for speedy trial. Thus, these facts also present a question of whether the trial court had lost jurisdiction to impose sentence. Questions of jurisdiction are afforded a de novo review. When we talk about ineffective assistance of counsel, I'm talking about ineffective assistance of both trial counsel and appellate counsel. This court, in its own opinions in Part 1 and Part 2, talked about we can't reach this, we can't reach that, this has been missed, we don't have information about this. This has not been elucidated for us. This is all what we are supposed to do as council, is to protect the constitutional rights of our clients. And when we do not do that, by raising whatever it is, I say the prejudice to Mr. Clark was at the very least a prolonged period in jail incarceration, occasioning the filing of a petition of habeas corpus to gain the attention of the court that he was still behind bars and no movement had occurred in his case. Let's talk for a minute about merger of allied offenses again. Because the judgment does not distinguish between the offenses of which the defendant was convicted, we must conclude that the defendant was convicted of identical offenses. That's State v. Johnson. We do not have qualms about the concurrent sentence imposed, but upon the number of counts to which it was applied. Practically, were Mr. Clark to at some point be released from prison, one count of rape, less than 10, and one count of gross sexual imposition would not have the same prejudicial effect as 3 counts of rape and 10 counts of gross sexual imposition. I also wish to talk about the fact that at some point the court says, and I elucidate this in the brief, rape is rape is rape. The court does not have the jurisdiction to decide force or threat, which is an element that they put in. And so based on something that they do not have the right to decide and the prosecution did not present any evidence on, they have miscalculated his sentence. We believe it should be 15 to life, not 25 to life. Now I still know that's a long time, but you know, 10 years is 10 years is 10 years. The other thing that I wish to bring, and I think my time is running out, so let me close with this. The de novo standard of review is a non-deferential standard of review. This means that the appellate court will not place any weight on any previous court's findings or judgments rendered. Instead, they are free to make a new decision or reverse the lower court's decision entirely. So it doesn't place any weight on previous court findings. Now, it is with that in mind that we ask this court to affirm. In cases like the one at the bar, the law is clear. This court was divested of the jurisdiction to construe the law that applies. The court remanded this case to the trial court to render proceedings consistent with its opinion that the conviction was vacated. This language was not open to interpretation.
Counsel, I'm gonna have to ask you to wrap up because you're over time.
I would just like to thank the court for any consideration that they give us in this matter. I tried to write the brief in a way where I hope and pray that you will understand and rule in our favor. Thank you so very much.
Thank you both very much for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy of that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you both again.
Thank you.
Thank you, Your Honor.